Actually, Dr. Singvi, you can read this para. I was also reflecting on it last night. See, the entirety of list 2, there's a legal fiction which we have to, as we always say, you shouldn't allow your mind to boggle. There is a legal fiction. There's a legal fiction in 239 AA, as a result of which the entirety of list 2 of the 7th schedule is basically a concurrent power.
Is made like a concurrent.
Is made like a concurrent power in relation to the UT of Delhi. So Parliament can legislate on the entirety of list 2.
Just like the state can also, the UT can also.
So that's the effect of it. Now, if Parliament can legislate with the entirety of list 2 in addition to list 1 and list 3, then Parliament has the power to legislate under entry 41 of list 2 also. Now, if Parliament has the legislative power on entry 41 of list 2, then there is no reason to take recourse to entry 97. You take
that's the short point I am making.
You take recourse to entry 97 and article 248, which is residuary power, where there is no provision elsewhere.
Very great respect, but I can't put it more pithily.
Because both the judgment in Dillon's case, which is followed in Dillon's case here, it says that in deciding as to whether Parliament has legislative competence, you ask yourself only one question. Is there any entry in list 2 which covers the field? If there is an entry in list 2, then Parliament has no legislative power. If there is no entry in list 2, then Parliament has to have power either under list 1 or list 3 or entry 97. That's Dillon. That's the residual power. That's right. But here, Parliament undoubtedly has powers on entry 41 of list 2 because of the
fact that it's a power. It's a concurrent. Just it will take less than 2 minutes. What your lordship has put, very interesting, Dillon, from two perspectives. One the negative, one the positive. I'll give you 2 cases. Just give me 2 minutes on that. I missed out para 13, which I'll come to after. Just come to 14 first.
Yes.
Just, it's one para each, your lordship need not go to the judgment. Just read from here. Read that as it may. I'm straight away coming. This is the reverse. In my favor, but in the reverse context. Just read it. In my favor, reverse context. Be that as it may, it is not necessary to pursue this line of reasoning since we are in total agreement with the approach evolved in Dillon. A decision by a constitutional bench of 7 judges, the test evolved in the said decision is where the competence of Parliament to enact a particular statute is questioned, comma, exactly what my Lord Chief Justice said. One must look at the several entries in list 2 to find out, applying the well-known principles in this behalf, including expansive reading, whether the said statute is relatable to any of those entries. If the statute does not relate to any of the entries in list 2, no further inquiry is necessary. That's why it's a reverse context. Right. It must be held that Parliament is competent to enact that statute, whether by list 1, list 3 or 97. Now read the next sentence. In this case, it is not even suggested that either of the 2 enactments in question are relatable to any entry in list 2. The opposite of my case. There cannot be an entry clearer than 41 on the subject we are discussing. Now see, the recent judgment to which my Lord Justice Shah was a party in the reverse direction, holding just the opposite, in my favor again, but in the context is reverse. This is 2022, citation is given there. But the question is whether, while interpreting entry 40 of list 1, alongside 34 and 62 of list 2, power to tax lotteries organized by the Government of India or the government of a state is also taken away from entry 62 of list 2 and is to be read within the ambit of entry 40 of list 1. And therefore, the states of Karnataka and Kerala in the instant cases had no competence to enact the included acts. We have already stated that only lotteries organized by the Government of India or the government of a state is carved out of the subject betting and gambling in list 2, entry 34 is list 2 months. It's carved out of betting and gambling in entry 34 list 2 and is placed in entry 40, only that part. Entry 62, inter alia speaks of tax on betting and gambling. But that we do not think by that the state legislature has been denuded of their power to levy tax under 62 of list 2 on lotteries organized by the Government of India or the Government of State. Please say so for the following reasons. Now, 6th reason. Entry 97 can be invoked only when any matter is not enumerated in list 2 or list 3. It's in the affirmative, in the other direction. Including any tax not mentioned in the said lists. There is no specific entry for levy of tax on betting and gambling in list 1. That's why entry 97 can't come in this. It is only in entry 62, then your lordship goes on. I don't want to read the whole of it. So this is clearly settled. Last point before I end, para 13, the para just above this. Para 30, 1.3, I have said it orally many times. I put it in writing, something in his favor. I've already said it many times.
Para 3.
1.3.
1.3. Of yesterday.
Just the preceding para of what I just said. Immediately preceding. And that is why the issue is a very narrow one. It doesn't actually, should not cause any heartburn to anybody. Kindly see this. The scheme of 239 AA provides adequate checks and balances for protection of national interests in the NCT of Delhi. This has been repeated so many times. Capital NCT Delhi. Look at this, fellas. The Constitution provides. What more protection can Lordship give than give Parliament the entire list too as a concurrent list? Can a Lordship give any more protection, fellas? The boss is Parliament, if I may use colloquial words, fellas. Nobody is denying that. The issue is absent Parliament exercising contrary power, contrary legislative power. Somebody in the concurrent list can't exercise the same power, in this case a UT. That's the issue. Now read this. A conjoint reading of 239 AA 3 and 4 posits that the conscious scheme adopted by Parliament in exercise of its constituent power, that is by constitutional amendment, is that the legislative power and concomitant coextensive executive power of the NCT, obviously not concerned with those 6 entries, can be legislatively overridden by Parliament. It's as simple as that. All this for the national security, capital of India, nothing. Parliament needs to make a law or an existing law needs to be applied to trump the exercise of power by the Assembly of NCT. I am saying this. He is not saying it, I am saying it. With deepest humility, Minister. Your Lordship is given a picture as if somebody is hijacking the national capital. Then, Union is seeking to obliterate. Now, this is very important. This is a nuance. It's a jurisprudential nuance which I am submitting for Lordship's kind consideration. There is a difference between Parliament and the central government. My problem is my learned friend is reading Parliament to be the central government. That is my problem. That is where the nub of the problem arises. Parliament, your Lordship, is given power to trump everything. He says central government should trump. What is happening in this case? The notification impugned is a central government notification. That is not Parliament. Please exercise your parliamentary power. The Union is seeking to obliterate the distinction between Parliament and central government. Under the present scheme, the Assembly of NCT has full play in any unoccupied field of an entry in list 2. Acceptance of the Union argument and upholding of the impugned notification would effectively endow the Union government with an executive override. Your Lordship gives him parliamentary override. He gives to himself executive override by the impugned notification, which I have said is nothing more than adding 41 to 1, 2 and 18 by executive order. That's the simple nub of this case. Endow the Union government with an executive override over the Assembly of NCT. This is clearly opposed to the fundamental scheme of 239 AA. It must be borne in mind that both legislative and executive checks that govern the exercise of power. 1. The entire list 2 for NCT effectively works as a concurrent list. Exactly what my Lord just observed. I am saying so myself. And this, I say, what I am saying is, of course, subject to my Lord's, harmonizes the whole thing. What he says will create a discordance. Because executive override of Parliament, of central government, can never be envisaged with a parliamentary override. The entire list for the NCT effectively works as a concurrent list. If any law made by Assembly is in conflict with a parliamentary law, the same can be reserved for consideration of the President. That's another Lordship knows concurrent list procedures. Further, in terms of the functioning of the executive, there's a difference power to refer. That's a separate one. Let's not get into that. Well, I only remains for me to thank your Lordships for a very patient hearing for both of us. Respect that constraints. May I end, Malas, in pre-independence times, Malas. Long before independence, Malas. The British still used to call it the Indian Civil Service. So Nehru made a very interesting comment. He says, it is neither Indian, nor civil, nor a service.
At that time.
Well, my submission is that at the end of this case, it is vital for your lordships to demarcate black and white the powers. Otherwise, well, it will be either less of a service or less of civil. It will remain Indian. Deeply obliged.
Thank you.
But immensely, more than patient hearing.
Thank you, Mr.
We are immensely.
I've done it within 1 hour, I want to repeat that.
No, you can.
It was a learning experience, my lord.
Thank you, Mr. Lister. Thank you, Dr. Singvi.
Thank you, everyone.
Very deeply obliged.